Covenant to insure. These are undertaken to ensure the demise premises by one of the parties to the lease or in the name of one or all of the parties. Insurance of the demise premises is necessary because the parties have insurable interest in the property. The landlord has reversionary interest and the tenant has possessory interest in the property. The insurance clause should cover the following: 1. Who is to insure; 2. The risk to be insured; 3. The amount of insurance cover; and 4. Application of the insurance money. On who is to insure, the following is to be considered: A. The nature of the property. Where part of the property is held by the lessor, it should insure the property to make sure a common policy covers the whole property. Where the lessee occupies an exclusively detached unit of the property, then the lessee should insure the property in his own name. Existing obligations. Where a party has been involved in the insuring of a property or has other existing obligations to insure the property, then it should insure the property. A good example is where the lessor charges the property for a loan and the bank requires him to insure the property. C. Payment of service charge. The insurance may be undertaken by the lessor who subsequently recover the money spent for the insurance as part of a service charge which the lessee is to pay. D. The risk in the use of the property. Where the property is to be used for a highly risky business, the lessee should insure the property. On the risk to be insured, the particular risk to be insured against should be expressly stated, if it is against loss or damage by fire. On amount of insurance cover, there shall be no cover in respect of an insurance risk unless the premium is paid. Section 50 of the Insurance Act. As such, a covenant on insurance should provide for the amount of the cover, which should not be less than the full cost of the reinstatement of the property. A person obliged to insure must not underinsure. On application of the insurance money, the lease should provide how the money to be collected from the insurance company is to be applied. Where the lessor insures, then the lessee does not have the right to compel him to expend the money to reinstate the damaged property unless the lessee pays for the insurance or reimburses the lessor for the insurance. The insurer has the right to choose whether to reinstate the property damaged by fire or to pay the insured for the loss suffered, but it shall not exceed the insured sum. An insurance clause may be drafted thus. Remedies for breach of covenant to insure. 1. Damages against the person who ought to insure but failed to do so. 2. An action for forfeiture if expressly provided. 3. An application to court by a person interested in a destroyed property to use the insurance money to reinstate the damaged property. Option to renew. This is otherwise known as a covenant for the renewal of the lease. This is a lessor's covenant made to the lessee that at the expiration of the lease, another lease will be created for similar or review terms, rent, and covenants. Where it is provided in the lease, it may be enforced against the lessor. The clause should contain the following: A. The time within which the application is to be made, 3 months or 6 months. B. The manner of the exercise, which is usually in writing. C. The condition precedent to be fulfilled before exercise of the option. D. The term of the new lease. Very important, the solicitor should be careful when drafting the covenant to ensure that no perpetually renewable lease is created. With Hopkins' case, the option to renew may be drafted thus. Proviso for forfeiture and re-entry. This may lead to the suspension or the termination of the lease for non-payment of rent or non-observance of covenants in the lease. It operates to bring the lease to an end earlier than it would otherwise have terminated. It is usually drafted as follows: provided always that if a tenant commits a breach of the covenant or conditions in the lease or becomes bankrupt, it shall be lawful for the lessor to re-enter the premises immediately the term shall absolutely cease and determine. The law presumes against forfeiture of leases except where the clause is expressly stated. The lessor is required to strictly prove the breach of covenant by the lessee in an action for forfeiture. Very important, in Lagos State, the right to forfeiture and re-entry in leases is implied. Where the lessor has waived his right to enforce covenant in the lease, he cannot be allowed to exercise the right for forfeiture. The lessor may enforce the clause in 2 ways: A. By peaceable re-entry, B. By an action for possession. Formal parts of a lease. 1. Commencement. This lease or this deed of lease. Where it is a tenancy, it is commenced thus: this tenancy agreement or this agreement. 2. Date: made this dash day of dash 20 dash. The date is the date the lease is made. Where it is by deed, the important date is the date of the delivery of the lease. In tenancy agreement, the important date is the date of execution. Three parties: between Mr. Dash of Dash hereinafter referred to as the lessor landlord and Ms. Dash of Dash hereinafter referred to as the lessee tenant. The full names, addresses, and occupation of the parties must be stated. 4. Recitals: it is usually not an essential part of a lease, however it may be useful in a sublease. 5. Testatum: whereby the lessor agrees to demise to the lessor, it is hereby agreed as follows. The lessor demises as follows. The testatum contains the operative words and the pass-through clause. 6. Pass-through clause: all that property situate and known as. 7. Habendum: to hold on to the lessee for dash term of years commencing on dash and ending on dash. Very important, the phrase commencing on includes the date named in computation, while commencing from excludes the name date. The addendum specifies the quantity, quality, duration, and commencement of the term of a lease. 8. Redundum: yielding and paying yearly during the term the sum of dash. The redundum defines the amount of rent payable by the lessee. The person to whom the rent is payable must be stated as well. The mode of payment is usually in advance. 9. Covenants. 10. Testimonium: a witness whereof the parties are bound to set their hands and seals in the manner below the day and year first above written. 11. Schedule: it should be inserted where necessary to describe the property in details. 12. Execution: this provides for the signature, mark, or seal of the parties to the lease, signed, sealed, and delivered by the within named lessor or lessee, or signed by the within named landlord tenant. Note that the difference between a tenancy agreement and a lease is the duration of the term demised. A tenancy agreement is 1 to 3 years, while a lease starts from 3 years. Attestation: this contains the witnesses to the lease and their signature in the presence of name, address, occupation, signature. For a corporate body, it is drafted as follows: the common seal of Dash Dash Limited is affixed to this lease and perfectly delivered in the presence of director and secretary. Sample draft of a tenancy agreement. Quick glance note is powered by Rooms and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Conic Close of Idemai Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 08142775425 091569137 and send your emails to ronumsandluxury@gmail.com, Instagram ronumsandluxury, Facebook ronumsandluxury, and call them for all your real estate questions. For sponsorship and advert placements, please contact 09125921620 or send an email to resistandpartners.chambers@gmail.com.